Questions for Article 160. A defendant may obtain sealing of one eligible felony offense, but not more than 2 eligible offenses. 2. A report of the termination of action by conviction for a non-criminal offense shall be sufficient notice of sealing to the Commissioner of the DCJS. So what that means is if somebody gets convicted, criminal possession of a controlled substance in the 7th degree, that's an A misdemeanor, so they have to be fingerprinted on it. So at the time that they get convicted, they take a plea, it gets reduced down to a violation, which is now not a crime, which would not be a fingerprintable offense. It gets sealed for the fingerprints, and that would have to be told to DCJS. So that's what that's talking about. Number 3, upon the termination of a criminal action or proceeding in favor of the accused, the arrest and prosecution shall be deemed a nullity. True. Upon the termination of a criminal action or proceeding in favor of the accused shall be restored in contemplation of law to the status he occupied before arrest and prosecution. True. If fingerprints of a person arrested are taken, palm prints and a photograph must also be taken. That is false. Palm prints and photograph may be taken. CPL 170. 1. Generally, if a 16 or 17-year-old is charged with Penal Law 230, is prostitution, or Penal Law 240-37, which is loitering for prostitution, so they're hanging out on the corner, the local criminal court may dismiss the charge in the interest of justice. This does not apply where charge is loitering for the purpose of patronizing a prostitute. So that would be the John. The prostitute, it can be dismissed in the interest of justice. The John, no. 2. If a youth is not in compliance during the pendency or disposition of the PINS proceeding, court may, upon application of the people, restore the accusatory instrument. Notice of such application must be served on the person and his or her counsel by the court, and that's CPL 170-80. And the court may convert charges to a PINS determination. CPL 170-10. A defendant must appear personally at arraignment, and that is false. There are exceptions, like anything. They are a corporate defendant, and 2, when responding to a summons or appearance ticket, court may permit the defendant to appear by counsel. So, they need to appear personally at arraignment, except when it's a corporation, or when responding to a summons or appearance ticket. They may permit the defendant to appear by counsel. 4. Court does not have to provide free counsel in certain traffic offenses charges, and that would be traffic infractions. They're allowed to represent themselves. Number 5, misdemeanor complaint must be replaced by an information unless the defendant consents. A misdemeanor information may be used as the basis for prosecution in all cases. However, a misdemeanor complaint can be used as a basis for prosecution if the defendant consents to it being used for that reason. 6, a securing order cannot release the defendant on his own recognizance. That's false. A securing order either sets bail, releases the person on his own recognizance, or remands in the custody of the sheriff. 7, a defendant in custody awaiting grand jury action must be released on his own recognizance if the grand jury has not acted within 45 days. 8, generally, criminal pretrial motions must be made within 45 days after arraignment and before commencement of the trial. Is that right? Yeah. 9, an ACD is in all cases for a maximum of period of 6 months. That is not true. It can be for 6 months. However, if it is a family offense, one of those offenses that's also the family offenses in family court, then it can be 1 year. And also if it's marijuana, it would be 1 year. 10, an ACD is an admission of guilt. It is not an admission of guilt. 11, generally, if a misdemeanor complaint is pending and the defendant is in custody, the defendant must be released on his own recognizance after 5 days, not including Sunday. 5 days, not including Sunday. Misdemeanor complaint, release, 5 days. 180, and we're going to go into some questions. This is number 1 from CPL 18010. Number 1, a preliminary hearing must be held when a defendant is held on a felony complaint for the action of the grand jury. That's false. That's false. Preliminary hearing may be held.
2.
CPL 18010. A felony arraignment, a securing order committing the defendant to custody must be made. That is false. Securing order can also fix bail or release the defendant on his own recognizance.
3.
Superior court judge sitting as local criminal court cannot try an action where the offense charged is a felony. I believe that's true. Yes, Superior Court judge sitting as a local criminal court cannot try an action where the offense charged is a felony.
4.
If a felony complaint is replaced by a misdemeanor complaint, the defendant must be arraigned upon the new accusatory instrument, and that is true. 5. The defendant, as a matter of right, may be present at a felony hearing. 6. At a felony hearing, the defendant may call witnesses if the court allows. So at a felony hearing, the defendant can call witnesses if the court says it's okay. 7, the court's determination at a felony hearing must be by reasonable cause to believe. So the determination at a felony hearing must be reasonable cause to believe. And you'll hear this if you've ever worked in district court, where I do. You'll hear them say, the DA will say, even though here it says the court's determination, but it'll say, although there's been reasonable cause to believe that a felony was committed, blah, 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 and then they'll drop it down to prosecutor's information and do whatever. Or they'll say that he was indicted. Okay. Number 8, removal of a juvenile offender case to family court is done pursuant to CPL 725. However, now with the adolescent offenders, they are done as per CPL 722. Number 9, a defendant held on a felony complaint must be ROR if a felony hearing is not held or the complaint remains undisposed for 120 hours or 144 hours, not including Saturday, Sunday, or a public holiday. When it says undisposed, that means like if they don't have a cert from the grand jury saying that the person has been indicted. So what happens a lot of times is they'll be waiting by the fax machine, waiting for the grand jury letter, basically saying that the grand jury indicted this person, and here's the certification, here's the indictment number, and they'll put it over for another date to hand up the actual indictment paperwork. Okay, this is CPL 190. Number 1, CPL 19010. The appellate division of each judicial department adopts rules governing grand juries. However, an extraordinary term of the grand jury may be ordered by a Supreme Court justice assigned to hold such term. 2. During deliberations and voting of grand jury, only grand jury members may be present in the grand jury room, except the sign language interpreter. Everybody else who doesn't understand English, I don't know how they're supposed to know what goes on. 3, 19040. A witness before the grand jury receives immunity unless he has waived immunity or evidence he gives is not responsive to any inquiry and is gratuitously given. 4, CPL 19080. Generally, upon application, a juvenile offender held on a felony complaint for the action of the grand jury must be released on his own recognizance if the grand jury has not acted for 30 days. 5. A grand jury is comprised of 16 to 23 people. 6. Who appoints the foreman and acting foreman of the grand jury? And that would be the court. 7. Who appoints the secretary of the grand jury? And that would be the grand jury. 8. For a grand jury to indict, at least 16 grand jurors must be present. To indict, agreement of at least 12 grand jurors is necessary. So, a grand jury is 16 to 23 people. To indict someone, there must be at least 16 grand jury members there, and at least 12 members need to agree to indict someone. It does not have to be unanimous. It's 12. 10. A charge dismissed by one grand jury cannot be resubmitted to another grand jury. That is actually false. A charge dismissed by one grand jury can be resubmitted to another grand jury, but after that, then that's it. 11. A person held on a felony complaint for the action of the grand jury must be released on his own recognizance if the grand jury has not acted for more than 45 days. So, if the grand jury has not acted on a felony complaint for a juvenile offender, it's 30 days. Needs to be ROR'd if he's in custody. A person held, a regular person, just not a juvenile offender, would be 45 days. And 12, 190.10, the consent of the DA is needed for the waiver of indictment. That's true, and it has to also be written and signed in open court with his attorney and consent of the DA. A grand jury may 1. Indict someone. 2. Ask the prosecutor to file a prosecutor's information. 3. Direct removal to the family court. 4. Dismiss it. Or 5. Give a report. The grand jury is made up of not less than 16, not more than 23 members. During its proceeding, the following may be present before the grand jury: the DA, the clerk or public servant. That's true. 190.25. During its proceedings, the following may be present before the grand jury: the DA, the clerk or public servant, and the attorney representing a witness when the witness is present. 7. The legal advisors of the grand jury are the court and the DA, are their legal advisors. 8. Generally, upon application, a defendant held on a felony complaint for the action of the grand jury must be released on his own recognizance if the grand jury has not acted more than 45 days.